Hello, everyone, and welcome to Uncivil Law. And for today's story, we're dealing with a marijuana-related tax case. So is it interesting because marijuana or uninteresting because tax? I guess we'll find out. This is Eric Spidell versus United States of America. In this case, Spidell operates a chain of marijuana stores in Colorado, which is legal under Colorado state law. Less legal under operative federal law, I'm sure we're all aware. And he is paying his taxes, and the IRS would like to audit him, and they would like to get access to his business records, and so forth and so on. So he is less thrilled about this prospect because it would mean turning over to the federal government evidence that could be used against him in a potential criminal proceeding about him, engaging in illegal trade. Not that it should be that hard to prove anyway, because apparently he runs a chain of these things. So if the government were really interested in going after him, probably wouldn't be that hard to figure it out. But he's not thrilled about turning over evidence to the government anyway. So we have to figure out whether or not the IRS can get this evidence as part of its tax proceedings, or whether or not it's an improper violation of the Constitution. Let's get started with this. This case involves two sets of appellants. The first set encompasses Green Earth Wellness, collectively known as the Green Solution Parties. Cool name. The Solution Parties are engaged in retail sale of marijuana and marijuana-related products, and they advertise themselves as Colorado's #1 marijuana dispensary, which I'm assuming has come to the attention of the federal government before. Pursuant to the operative federal law, the IRS is auditing the Green Solutions Party's tax returns for 2013 and 2014. Because some of the Green Solution businesses are pass-through entities for tax purposes, the IRS investigation includes Spidell's individual tax returns. So we don't really need to get into the minutia here, but certain kinds of businesses are more insulated from the individual than other kinds of businesses. So you can have business arrangements where the individual is distinct from the business, and you can have them where it's less so. So the furthest that you can go is probably the true corporation, or even an LLC is the farthest you can go on one extreme, and the other extreme would be sole proprietor, where there's essentially no distinction between you and the business. So to say it's a pass-through entity is to say it's closer to the sole proprietor category. These are businesses that are not really distinct from you, and so the income of the business is more your income. So as a result of that, we have to audit your tax returns because they're not individually distinct. So that's kind of what they're talking about there. The IRS requested information and sent summons to Green Solutions, but only received partial responses that were insufficient to substantiate the figures shown on their tax returns. So it's like, we want your books, presumably, and they didn't get copies of the full books. Among other things, the Green Solution Parties did not produce information reported to Colorado's Marijuana Enforcement Division. So the information we gave specifically to its marijuana enforcement, which is probably very documentative of illegal activity, one would imagine, including information from the Marijuana Enforcement Tracking Reports and Compliance System. The IRS contends this information is particularly valuable during an audit because in California, marijuana growers and dispensaries must account for all marijuana plants and products through the law, thus potentially confirming whether marijuana business properly reported its gross receipts and allowed deductions for costs of goods sold. The Green Solution Party is petitioned to quash the IRS summons. In a series of orders, the district court denied the motion to quash and granted the subpoena. You must turn over these business documents. Among other things, the district court held the IRS has a legitimate purpose in issuing the summons because the IRS has authority to determine whether a taxpayer is trafficking in a controlled substance, which for the purposes of the tax law is pretty important because you can't take deductions related to the controlled substance. You have to pay taxes on it, and you can't take business expenses related to it. The information sought is not already in the IRS position and was relevant to determining Green Solutions Party's tax obligations, presumably, yes, and the IRS followed the required administrative steps, and Green Solution Parties did not show that this was an abusive process or bad faith because there was no proof the IRS was seeking to place them in criminal jeopardy. So yeah, the IRS's purpose here is for tax enforcement, and the tax law as it relates to this is, pretty annoying if you're a business in this position because you can't deduct business-related expenses like you can for any other business. So it's a very expensive proposition, and part of this income is flowing to you personally. And so the IRS would like to determine whether or not you're taking in any improper deductions, either deliberately or otherwise, to make sure your taxes are correct. And so they like the information that shows that. And yeah, so they're not necessarily trying to put you in criminal jeopardy. They're just trying to prove that you paid your taxes or not. So, okay. The second set of appellants encompasses the medical wellness parties. Pursuant to law, the IRS is auditing these parties' tax returns from 2014 through 16. Because some of medicinal wellness businesses are also pass-through entities, see our earlier discussion on that, the IRS investigation includes personal tax returns of those people. The IRS sent document requests to summons to the parties, but only received partial responses that were not sufficient. The medical wellness parties say they requested immunity for prosecution before presenting further information. Good on them. But the IRS declined to request after consulting with the attorney's office. So it's like, I want immunity, and the IRS says, no, you don't get immunity because I need to see your business records to see what taxes you're paying or not. Okay. Among other things, the district court held the IRS had a legitimate purpose in issuing the summons because there was no pending criminal investigation and no right among the parties to demand immunity or invoke privilege against self-incrimination. Incidentally, for what it's worth, the privilege against self-incrimination only applies to testimony, which is to say words that come from your mouth. Testimony does not include, in any context, written documents. That is not a Fifth Amendment interest. That's a Fourth Amendment interest for the seizure of papers, but not a Fifth Amendment privilege because of self-incrimination, and never has been. So the government can get your diary, for example, which is very, very personal, but it is not testimony because it is not coming from the contents of your mind. They want a physical document. What those physical document reveals or not is not testimony and not covered by self-privilege. So there's no Fifth Amendment right here. That makes total sense. The information sought was not already in the IRS's possession and was relevant to determining the tax obligations. The IRS followed all the required steps, and the parties did not show abuse of process because the summons did have a valid purpose. It was not a fishing expedition seeking materials outside their control, so they weren't trying to get access to other records other than yours. They want your records. They didn't run afoul of any Fourth Amendment right to privacy, seizure of records, and they didn't violate the respective Colorado law. Okay, so the IRS would like copies of certain business records, including records turned over to marijuana authorities within the state of Colorado, presumably showing all the plants they purchased and all the sales they made, probably very specifically tied to serial numbers and other tracking numbers, probably pretty detailed information, I would take a guess. And they're not super thrilled about turning over this information to the IRS. So how is it determined whether the IRS can get access to information as part of an audit or other IRS proceeding? Let's look at the law. In general, the IRS has broad latitude to issue summons for the purpose of ascertaining the correctness of any return, making a return where none has been made, determining the liability of any person for tax, or collecting the liability. However, the IRS must show that it has not made a referral of the case to the DOJ for criminal prosecution, which, probably isn't true at this point. They're just in an audit. They haven't already turned it over to the DOJ, no. Thereafter, the IRS must demonstrate good faith in issuing the summons, which means establishing what's become known as Powell factors. Powell requires the IRS to establish the investigation will be conducted pursuant to a legitimate purpose, the inquiry may be relevant to the purpose, the information sought is not already within the IRS's possession, and the administrative steps have been followed in the tax code. The appellants have not pointed to competent evidence contradicting the IRS's denial that the cases at issue have been referred to the DOJ for prosecution. Nor have the appellants pointed to evidence contradicting the IRS's explanation of the purpose of the audits of the respective parties. Among other things, the IRS states the agency is involved in investigating federal tax liability, verifying accounting records, reconstructing income to figure out what income happened, substantiating tax records, and confirming business relationships exist. The appellant maintains the IRS lacks authority to decide whether the appellant's conduct is prohibited by the Controlled Substances Act, which is definitely true. The IRS doesn't determine that. That's correct. And the IRS's powers do not supersede or preempt Colorado law, and neither argument has legs. We have rejected the appellant's lack of authority argument several times, most recently in Standing Acabino. We said the taxpayers argue the IRS acted with illegitimate purpose, namely investigating federal drug crimes. We have already rejected this argument. In 2017, we observed the IRS's obligation to determine whether and when to deny deductions under the relevant law falls squarely within its authority of the tax code. The next year we have held it's within the IRS's statutory authority to determine, as a matter of civil tax law, whether taxpayers have trafficked in controlled substances for the purposes of the tax law. Most recently in High Desert, we relied on Green Solution and Glow to determine the IRS has statutory authority to make a determination that Congress expressly asked it to make, even if the determination requires the IRS to ascertain where the taxpayer is engaged in conduct that could subject him to criminal law under the CSA, or, really any criminal law for that matter. So even if the IRS has in fact issued the summons to investigate federal drug law, the taxpayers have furnished no evidence of that, and the IRS could still do the determination as part of the applicability. So, every government agency is tasked with its respective tasks. The IRS is tasked with figuring out tax. That is their role in life. They are definitely not here to figure out whether or not that someone violated the Controlled Substances Act. The IRS does not care. Someone else in the federal government may care, but not the IRS. The IRS is only here to figure out the tax. And, certain deductions are allowed and certainly some not, particularly if you're engaged in illegal trade. You still have to pay taxes on it, and you can't normally take business expenses. So the IRS is simply trying to figure out, as far as the IRS is concerned, whether or not you've paid the tax owed, which is their job. And they want the business records to be able to make that determination. We have also rejected the argument that there's a preemption problem and that the federal law may have improperly preempted Colorado-specific law. Once more, we've explained why this argument is not persuasive. The Controlled Substances Act doesn't have to preempt the Colorado law with respect to this particular IRS law. That doesn't even really make 100% sense. Why would the Controlled Substances Act preempt with respect to the tax law? That would be a little weird. The section of the tax law applies when business activities consist of trafficking in controlled substances within the meaning of Schedules 1 or 2 of the Controlled Substances Act, which is prohibited by federal law or the law of any state in which such trade or business is conducted. Congress's use of the word "or" extends the situation in which federal law prohibits conduct even if state law allows it. Yeah, whether or not you have to pay taxes under state law is not in interest of the federal government. Further, the Controlled Substance Act reigns supreme. State legalization of marijuana cannot overcome the federal law. Very true. So despite legally operating under Colorado state law, the federal government, not so much. Taxpayers are subject to greater federal tax liability because, as far as the federal government is concerned, these are illegal activities. And the remedy must come from congressional change to the operative statute, or rather than from the courts. The appellants next try to argue that the summons that they got only vaguely request reports. We don't know what you wanted. Sure. And as construed by the district court, the summons amount to overly broad fishing expeditions. The taxpayers in the prior case failed to provide competent evidence that any summons forced the creation of documents. This same is true for these appellants here. Regardless, if they don't have the reports, then by the IRS guidelines, they don't need to create them. Nothing requires them to create records, and the summons don't purport to say otherwise. So this was really a super Hail Mary argument that doesn't even begin to make sense. But I suppose when you're desperate, you'll try anything. So they say the subpoena for reports is vague because maybe we have to create the reports. No, because that's not how this works. That's not how any of this works. We're not asking you to create reports. We're asking for reports that exist. We're asking for documents that exist. If they don't exist, then tell us that they don't exist. That would be a valid response to a subpoena. I can subpoena you for anything. As was once said by another lawyer in a very funny letter. A subpoena, only strictly speaking, requests documents. It only requires you to turn over that which you already have. If you don't have it, I can't force you to turn it over. So he says, well, I might have to create the records. And the court's like, what are you talking about? No, you don't have to create records. They just want the records that already exist or not. If they don't exist, tell them they don't exist. What are you talking about? This argument's stupid. Thus, that brings us to the end of the case of Eric Speidel versus the United States of America in the form of the IRS. In this case, Mr. Speidel runs a marijuana dispensary in the state of Colorado, which is legal under Colorado state law, a little bit less so under federal law. And the federal law has specific requirements when it comes to tax. Most operatively, you can't take business deductions for illegal businesses, so it makes the business much more expensive. And the government would like access to certain records that he has that might show what taxes he has to pay or not. He says, well, that might expose me criminally. Well, first of all, the fact that you advertise yourself as the #1 dispensary in Colorado was kind of already a clue to the federal government if they were paying any attention at all. So if they were wondering, I wonder if this guy sells marijuana, I think they're kind of already there. So whatever criminal liability you have, I don't think it was really helping that much. And second of all, the IRS is not engaged in a criminal proceeding. They just want to know if you paid your taxes, and they want to get access to the records. And if you don't have them, you don't have to turn them over. But give them the business records, and yeah. So that is perfectly normal. This is perfectly ordinary IRS behavior. And for the moment, at least, that brings us to the end of the discussion of this case.